My name is Richard Brown. I'm the Chief Judge of the Wisconsin Court of Appeals. I am also a commissioner on the ABA Commission for Disability Rights. The Commission is sponsoring a resolution along with many co-sponsors at the mid-year meeting of the ABA. And that resolution would be geared towards asking the LSAT to be more vigilant in providing equal accommodations to those with disabilities. LSAT has a long history of not providing those disabilities. We have anecdotal and accurate actual evidence that LSAT frequently gives the runaround to people who ask for accommodations. And then if people with disabilities such as blind people, people who have trouble ambulating, people who are deaf, if they take the test and they take the test with an accommodation, their test results are flagged. That means that the LSAT people suggest a demerit based on what the accommodation was given, and the points are deducted from the actual LSAT test. Obviously, the law schools are going to look at this, and this is going to make a problem for those people who took the test. Now, the question becomes, is flagging necessary? Most of the empirical data, and I say most because there's one that says that, yes, it's necessary. Most of the empirical data, it says absolutely that there is no reason for flagging because the accommodation does one thing and one thing only, and that is to make it equal for that person, just as equal as for a person who doesn't have a disability to take that test. So, for instance, if a blind person uses a reader with Braille, that person is allowed to use that, should be allowed to use that. The LSAT people say no. LSAT people say, no, what we're going to do is we're going to give you a human being reader, and the reader will read the question to the person who's blind. And that's something that the person who is blind has had no experience with. And oftentimes the reader gets the question wrong. So it's a real problem. It used to be that everybody flagged, the SATs, the Graduate Record Board, the medical boards, the ACT, and now none of them do it. Because after they got this data saying that it's not real and it's actually a false positive, that it should not be, they should not do it anymore, and they stopped doing it. All except LSAT. The Oregon State Bar just did it, so Wisconsin's following on the heels of Oregon, the Philadelphia Bar, the Utah Bar. People on the commission and people who are close to the commission are going to their individual state bars and asking for co-sponsorship.